at this point in time. All right. Well, again, thank you, folks. Appreciate you're all here. Let me take care of reiterating the caption. This is the State of Washington versus Mr. Caleb J. Sharpe. Cause number in Superior Court. To be correct, in Juvenile Court in the State of Washington, County of Spokane, is 17-8-005955. The state is represented by Mr. Larry Haskell and Ms. Kelly Fitzgerald. Mr. Sharpe is represented by Mr. Bevan Maxey and Mr. Morgan Maxey. So first, I'd like to make a comment regarding the quality of representation. It's not necessary that I do this, but I feel compelled to say a few things regarding counsel's presentation. Regarding the State of Washington, Mr. Haskell and Ms. Fitzgerald were very well prepared, provided excellent and thorough representation to the State of Washington. And counsel, I thank you for that. Regarding Mr. Sharpe, both Mr. Morgan Maxey and Mr. Bevan Maxey were well prepared and provided excellent and thorough representation to their client, Mr. Sharpe. And counsel, for that, I thank you. Now, historically, I'm in my 17th year here in the Superior Court on this bench, and over the years I've been called upon to make a number of decisions, frankly hundreds and hundreds of rulings I've had to make as a Superior Court judge. Some of these rulings, especially in the criminal realm, I literally only have minutes to make. That's not just true for myself, but it's true for my judicial colleagues. It can be very frustrating when you're a judge and you're called upon so often to make extremely important decisions with almost no time to prepare. That's part of the job. But that said, judges are sometimes faced with the opposite situation. That is, a case where you really have an extraordinary volume of information to consider, which is, of course, helpful and highly relevant, but it can also be overwhelming, especially true when the decision is so extraordinarily important. And in this case, the court is faced with an absolutely extraordinary amount of information that must be reviewed and considered. As part of this proceeding, I have reviewed literally hundreds of pages that are part of the multi-volume Superior Court file. I have reviewed pertinent case law. Some of that case law I've read multiple times. I've reviewed medical records. I've reviewed school records, police reports, and of course, expert opinions and expert testing results. All of this must be reviewed for the court to make a thorough decision in this case. I heard days of testimony from citizens, from experts, from law enforcement officers, and of course, victims, and all of this must be given the strongest consideration by the court. I go through all of this to help everyone understand that I have given all of this information strong and careful consideration. I have spent countless hours in consideration of my ruling today, and I can say with certainty that this is undoubtedly one of the most difficult decisions I've ever been required to make as a Superior Court judge. I'd also like to say a few things to the Freeman community. First and foremost, I am so very sorry for your loss. That sorrow that I feel extends to everyone. It extends to Mr. Sharpe's family. Their pain is also extraordinary, and in many ways, they have also lost a child as part of this tragedy. One further point before I get into the specifics of the court's decision today, and that is to comment on the work done by law enforcement and to comment on some of the delays that I know have been frustrating to those who have been waiting for this case to move forward. I know some of you have been frustrated by the passage of time and delays that are difficult to understand. And in that regard, I want you to all know that these delays have been necessary, and they have been allowed by this judicial officer a number of continuances that have been absolutely necessary, given the absolute extraordinary volume of information that had to be sorted through. The public has seen only a very small part of this information that had to be compiled before we could proceed. And I can tell you, I have seen an investigation as thorough and complete as could ever be expected in this matter, and understand everything that law enforcement does, every bit of evidence they uncover, everything they research as part of their investigation must not also just be presented to the state, it has to be presented to the defense. The defense has a right to this information and a right to review and, if appropriate, respond to everything that the state has. All of this takes time, and it is a hallmark of our justice system in the United States. And it is, of course, especially important when we're addressing a juvenile and criminal justice in the juvenile system altogether. And all of this, of course, is frustrating when you're a victim or you're a family member or other interested party and you're waiting for this case to come to an end. I spent a little bit of extra time on this so you'll all know that the many law enforcement officers involved in this case have performed admirably. And their work, which I have reviewed over and over again, has been nothing short of stellar. And I want to thank them for that. This was an investigation where every I was dotted and every T was crossed by law enforcement. So, with those initial comments, let's turn to the declination hearing. Of course, I heard, and all of you heard, a tremendous amount of testimony from experts. Some of those experts are renowned. And over the last week, most of what I heard from these experts was new to me. What I knew beforehand, and to an extent many in the public were unaware of, was all of the planning and detail that went into this attack on Freeman School and its students. While we've spent a great deal of time in this hearing trying to understand why Mr. Sharpe did what he did, whether it's because of neurodevelopmental issues or delays in that regard, or lack of maturity, or a hypoxic event at birth, or the fact that Mr. Sharpe was a blue baby upon his birth, or simply the fact that he was becoming isolated in many ways, the court could go on and on about what I have heard in this hearing and potential explanations for what took place, all of which, by the way, will only ever be theory, because no one can absolutely, truly, completely explain why Caleb Sharpe did this. Which brings me back to, again, what I know. I know that Mr. Sharpe planned this assault in great detail, and what has been described in this hearing is almost a militaristic planning style. I know that Mr. Sharpe carefully planned how he would get multiple weapons into this school successfully. I know Mr. Sharpe engaged in a ruse with the bus driver that allowed him to bring a golf bag full of weapons and full of ammunition on the school bus. And on that day of the shooting, he provided friendly greetings to the bus driver while entering and exiting the bus. That is, nothing at all in his behavior on September 13th, 2017 to those who observed him prior caused any concern. Bus driver had no reason to be concerned that day. When the alarm was going off in the distance as she was cleaning out the bus, she didn't even suspect that it was because the school was on lockdown. I know that Mr. Sharpe drew a map of the Freeman campus and planned in detail exactly how he would enter the building that day, and specifically what route he would take from the bus stop directly to the door he planned to enter. and the stairs he would climb to the hallway where he knew potentially hundreds of students would be gathering on that day. I know that somehow Mr. Sharpe was able to learn the combination of the gun safe at the family home, and that weapons and ammunition were not inadvertently or carelessly left out for him to access. Instead, Mr. Sharpe sought out and specifically availed himself of weapons and ammunition that he would take to Freeman School on September 3rd, 2017. I also know that one of those weapons was a military-style AR-15 type assault weapon, specifically designed to inflict maximum carnage and death upon those who the weapon would be used upon. I also know that but for a fortuitous and perhaps, as Mr. Haskell called it, miraculous jamming of that weapon, when Mr. Sharpe attempted to fire it, we would, in all likelihood, be dealing with dozens of students and faculty who would likely have been killed or shot. I know that Mr. Sharpe authored a note which he gave to several students prior to September 13th, 2017, advising those students they would not be seeing him again after the 13th, which those students assumed was perhaps a reference to Mr. Sharpe taking his own life. I also know that when Mr. Sharpe was in place at Freeman School on the day in question, he calmly began unloading his weapons and appeared to make no attempt to conceal what he was doing at all. So much so that when Mr. Strahan approached Mr. Sharpe and spoke to him, Mr. Sharpe's demeanor and his mannerisms were so calm and methodical that Mr. Strahan was completely unaware of the peril he faced approaching Mr. Sharpe, who had an unzipped golf bag on the floor full of ammunition and weapons clearly visible. I also know that when Mr. Sharpe shot Mr. Strahan in the abdomen, he didn't stop or otherwise take a step back and reconsider his extraordinary actions. Instead, he followed up. He shot Mr. Strahan in the right cheek, all but guaranteeing that Mr. Strahan would die. I also know that at this point, Mr. Sharpe, clearly aware that he had taken a life, began to methodically fire his Colt .32 caliber handgun at students who were gathered in the second floor hallway, striking 3 students. The shooting with the Colt .32 caliber did not stop until Mr. Sharpe ran out of ammunition. I also know that in further preparation for this shooting, Mr. Sharpe shaved his head and had at some point drawn an X across the face of a number of students in the Freeman High School yearbook and had written the word "kill," as well as writing out in detail what appears to be a recipe for a homemade bomb. I also know that on September 12th, 2017, one day before this shooting, Mr. Sharpe's final determining factor in deciding whether to carry out this attack was a coin toss. A coin toss to decide if Mr. Sharpe's Freeman High School classmates would live or if they would die. Sadly, we know what the result of that coin toss was. I don't think I need to spend much more time on the factual background of this case. The record is already replete with information about what happened here. I do feel compelled, however, to say how much this case has affected Spokane County as a whole, and primarily the Freeman community. And that cannot be overstated. One witness after another testified that they will never be the same, and Freeman will never be the same. How can a teacher or a Freeman faculty member walk down that second floor hallway ever again without being reminded of the profound events that took place there? Of course, they cannot. All of this said, I cannot remember a time in my life when I have been so extraordinarily impressed by anyone. And I mean anyone here to encompass all of the Freeman community. There have been so many individual acts of heroism the court heard about and bravery that took place here. It would be inappropriate for me to single anyone out. You all know who you are. And I feel privileged to be part of this case, albeit in a very small way. Now, over the last week, I have heard from superb and incredibly knowledgeable experts. In some instances, some of those experts are nationally and even internationally renowned. I have great respect for all of these professionals that the court has heard from during this hearing. Now, folks who have been intensely listening to this testimony may wonder how it is that such educated and brilliant people can have such stunningly different opinions about the very same thing. And it's not that one is right and the other is wrong, not at all. But understand, this isn't like calculus, it's not even like arithmetic. The more complex an issue is, the greater the opportunity becomes for experts to disagree. But there is one thing for certain that none of these experts disagreed about, and that is the adolescent brain. It is now well known, and it is established science, that children's brains do not develop fully until, in general, their mid-20s. The science is clear that adolescent boys in particular, their brains don't develop as rapidly as girls, and now some experts are actually opining that young men do not fully mature in terms of their decision-making abilities until perhaps as late as 30 years old. Not to make light of this, please don't take this in any such way, but a well-known comedian used to do an entire comedy routine about this. An entire routine where that comedian would talk about the bizarre and unexplainable things his teenage son would do. And he would joke about asking his son, "Did you mean to shave your head and spray paint half of it green?" To which the boy would answer, "I don't know." "Is this the style of haircut that you wanted?" "I don't know." And it's all very funny when you hear it in a comedy routine. I'm not attempting to make light of any of this. I'm just pointing this out because this simply and clearly shows what we see in our children all the time, and particularly in our teenage children. That is bizarre, foolish, unexplainable, seemingly nonsensical behavior that we as adults would never do. But that's because we are adults in the time sense. Our brains and our decision-making abilities are fully developed. Or said another way, we know better because we're adults. And for the most part, absent exceptional circumstances, we as adults don't have any excuse. But this is precisely why we have adult court and we have juvenile court. It's why we have jail for adults and detention for juveniles. It's why we don't house juveniles and adults together. And in short, it's why we have categorically different penalties that are assessed against juveniles that are profoundly different than criminal penalties assessed against adults who may violate the law. Adults know better. Children, for the most part, do not. So where the law becomes tricky and is subject to significant judicial discretion is thankfully only in those very rare circumstances when a child commits a heinous and horrific crime. In those circumstances, should we impose the same limited penalty upon the juvenile, which traditionally ends at 21, when an adult in the same or similar circumstances could potentially be faced with life in prison? The allegations here are that Mr. Sharpe, on September 13th, 2017, went to his high school, Freeman, and shot and killed a classmate, and then shot 3 other classmates, seriously injuring them, combined with a separate and significant allegation of 51 separate counts of second-degree assault as to the other Freeman students who were in the immediate area of the shooting. As an adult, these charges are all what we refer to as Class A serious and violent felonies. First-degree murder with aggravating circumstances is, in fact, the most serious charge a person can face in the state of Washington, pursuant to RCW 994A 541A. The minimum term for first-degree murder is 20 years of total confinement. Counts 2, 3, and 4 in this case would run consecutively to count 1. That is, to that time ordered in count 1, while the 51 counts of second-degree assault would run concurrent with counts 1 through 4. Then there are firearm enhancements that would run consecutively to the previously stated counts. Said perhaps a more simplistic and understandable way, under the adult sentencing scheme pursuant to the SRA, an adult alleged to have committed the same acts as Mr. Sharpe, if convicted, would be facing a life sentence. Actually, that adult would be facing a number of months that would, without doubt, far exceed a human life. Under a juvenile disposition, which is where this matter currently sits, the total time wherein Mr. Sharpe could be confined, pursuant to RCW 1340, is 264 weeks, or 22 months. That is because, since Mr. Sharpe was born on October 10th, 2001, and was arrested on September 13th, 2017, and assuming he is subject to juvenile court jurisdiction, jurisdiction by law must end upon Mr. Sharpe's 21st birthday. Again, 264 weeks, assuming Mr. Sharpe would be detained following the murder of 1 person, attempted murder of 3 others, and second-degree assault of 51 others. More than 50 years ago, the United States Supreme Court issued its decision in the matter of Kent versus United States, which can be found at 383 U.S. 541. It is a 1966 case. The Kent case is still and remains a landmark decision in the area of juvenile law. And though there have certainly been significant changes in juvenile law in the last 50 years, not just in Washington state, but across the country, the so-called Kent criteria was formally adopted by the Washington State Supreme Court in the matter of State v. Williams. That case can be found at 75 Washington 2nd, 604. It is a 1969 case. There are 8 specific factors, and all are relevant factors for the court to consider in determining whether a matter should be declined by the juvenile court and therefore go forward in adult court. The so-called Kent factors. It is the state's burden to show, by a preponderance of the evidence, that declination is in the best interest of the juvenile or the public. Although all 8 factors are important in the Kent matter and should be considered by the court, no one factor is determinative. No one factor is controlling. They're all just to be considered by the court in its overall analysis. Factor number 1 is the seriousness of the alleged offense to the community and whether the protection of the community requires declination. Well, in this case, the impact of Mr. Sharpe's actions on the Freeman community cannot be overstated. A child died. 3 children were shot. 51 other children in the immediate vicinity are alleged victims of second-degree assault. One witness after another testified that students actually left Freeman School after this. Faculty members decided not to return. Even the school's law enforcement resource officer testified as to his serious reservations about returning to Freeman or leaving his position after the shooting. Students who heard a balloon pop at a restaurant started diving under the table for cover. Their fear and anxiety is so extreme. The school's janitor looks down the hallway where the shooting occurred on the anniversary of that shooting to see a shadowy figure kneeling in the hallway on that one-year anniversary of the shooting, only to learn the person is the parent of one of the victims of the shooting on September 13th, 2017. Clearly, the Freeman community continues to grieve. They continue to experience extreme levels of anxiety and fear, and it is not unreasonable to expect these events will haunt the Freeman community and certainly the direct victims forever. Factor number one in this instance weighs heavily in favor of decline. Factor number two is whether the alleged offense was committed in an aggressive, violent, and/or premeditated manner. All of this is true in this instance. This event was aggressive. It was extraordinarily violent and was absolutely premeditated. Nothing about this was spontaneous. Instead, it was planned. And as was pointed out to the court, the planning was done with militaristic precision. And at least immediately after the shooting, in speaking to Detective Bonney, Mr. Sharpe expressed what appeared to be no remorse whatsoever. Mr. Sharpe's planning even included using earplugs to protect his hearing from the sound of firing weapons in the school hallway. He planned this attack to occur in the school's busiest hallway at a time when the hall would be certain to be filled with students. The intricacies of Mr. Sharpe's planning go on and on. Factor number two clearly weighs heavily in favor of decline. Kent factor number three is whether the alleged offense is against persons or property. Here, this offense is most certainly against property, but that's really inconsequential when we have one student who has died and 3 others who are shot, and 51 other students in that same hallway who are allegedly victims of second-degree assault. Here, unlike a robbery, where a defendant brandishes a weapon and shoots a store clerk by accident, never intending to cause physical harm, never intending for things to play out this way, never intending to harm anyone. Harm was, in this instance, exactly Mr. Sharpe's intention: to cause as much carnage and death as possible. This factor weighs in favor of decline. Factor number 4 is whether there are prospective merits to the complaint, which has been defined as whether there is evidence upon which a grand jury may be expected to return an indictment. Well, in this matter, there is certainly a wealth of evidence in support of a finding of probable cause to find that Mr. Sharpe shot and killed 1 student, shot and seriously injured 3 others, and perpetrated second-degree assault against another 51 students. Mr. Sharpe essentially admitted to all of this in his recorded interview with Detective Bonney. Factor number 4 weighs in favor of declination. Factor number 5 is desirability of trial and disposition of the entire matter in one court, and whether the juvenile's associates were adults. As counsel pointed out, this factor really does not apply. There is virtually no evidence of participation, planning, and execution of these crimes by anyone except the respondent, Caleb Sharpe. Factor number 6 is the sophistication and maturity of the juvenile. A great deal of time and testimony and argument was centered on this factor, appropriately so. It is important to note that Mr. Sharpe's birthday is October 10th. This shooting occurred on September 13th, 2017, which was only 27 days before Mr. Sharpe's 16th birthday, which means that pursuant to Washington law, there is a mere 27 days that would need to pass before Mr. Sharpe's actions would have automatically subjected him to what we call auto adult, meaning, although a juvenile, his birthday and these dates mandate that this matter is heard in the adult court. Now, the court has heard about some educational challenges Mr. Sharpe faced. Problems with organization, challenges with mathematics, problems with his handwriting going back to elementary school, and so on. At the same time, the court heard that Mr. Sharpe has exhibited talent. He has advanced skills in reading comprehension and oratory skills. Mr. Sharpe was, in short, described as very bright and not unusually struggling with perhaps one or two academic issues. Not all that unusual. Interestingly, there appears to be virtually no behavioral issues whatsoever of concern that were discussed in this hearing. No trouble at school, no contact ever with juvenile court, no contact ever with law enforcement. Mr. Sharpe was described as friendly, courteous, respectful, funny. If anything, Mr. Sharpe was noted as perhaps a bit quiet and reserved, and perhaps to a certain extent would keep to himself. But that's it. Now, although the planning that went into Mr. Sharpe's actions on September 13th, 2017 appears to be sophisticated, nothing in Mr. Sharpe's everyday life prior to September 13th, 2017 seems particularly exceptional, or on the other side, distressing. He was described by some witnesses as perhaps immature for his age. Similar to factor 5, I really can't find any weight in favor or in disfavor of declination as to this particular Kent factor. So the court turns now to factor 7, which is whether the offender has criminal history or previous contacts with law enforcement and juvenile authorities. As I just stated, Mr. Sharpe has had absolutely no contact with law enforcement or the juvenile court. Nothing. He's not on anybody's radar. No disciplinary notices or reprimands at school. If one expected that we would hear a history of trouble or concerns about Mr. Sharpe that should have been clear to everyone that knew him, there's absolutely nothing at all that the court heard that would suggest that. I've heard about videos Mr. Sharpe made, and videos and documentaries about school shootings that he watched that are perhaps concerning, and video games he played that are very violent. But that said, how many kids are out there watching videos just like Mr. Sharpe was watching, and playing video games that are violent, just like Mr. Sharpe was playing, and nothing happens? Can these be predictors? Now, there's simply no way to make an absolute and direct correlation. Now, I know Mr. Sharpe wrote to a few classmates shortly before the shooting. Those classmates found this concerning, and as a result, the school was put on notice. But how can anyone realistically fault the Freeman School administration or a school mental health professional for not somehow divining that Mr. Sharpe was planning to commit a mass shooting? Even Mr. Sharpe's parents and siblings were shocked, dismayed by this crime. That's because while some who testified have described Mr. Sharpe as immature, he was able to carry all of this out with an extraordinary degree of deception, and nobody picked up on it at all. To the court, that actually shows maturity to an extraordinary degree, not immaturity. What Mr. Sharpe was doing with all of those he was close to and whom he interacted with was acting to such a degree that virtually everyone was shocked on September 13th, 2017, that the young man who carried all of this out was Caleb Sharpe. So, this factor would suggest to the court that the matter should remain with the juvenile court. Turning then to factor number 8 of the Kent factors, which is prospects for adequate protection of the public versus likelihood of rehabilitation in the juvenile system. Again, this is a factor a significant amount of time was appropriately spent on. And this factor is extremely telling in this case to this judicial officer. So let's talk about the rehabilitative aspect of this. Is it possible for Mr. Sharpe to be rehabilitated? Maybe. But even with the extraordinary array of expert witnesses who I heard from and who I've made clear I have great respect for, no one can guarantee that Mr. Sharpe would not spend his time in juvenile at JRA putting on a happy face. He may even be a model for other juveniles to follow, who seems to have advanced through the system and done well. He's held out at JRA as a successful rehabilitative candidate. Then he gets out at age 21. Remember, that's the maximum that he can be held in the juvenile system. And the next day, he carries out a mass shooting that he's been planning the entire time. Preposterous? Perhaps. Maybe. But who can tell me, who can tell any of us, who can tell the Freeman community that this won't happen again? The only difference that Mr. Sharpe has been given and would have been given by the court if he remained in the juvenile system is more time. More time to analyze his mistakes, more time to perfect his techniques, so that next time it's not one person killed and 3 people shot, maybe it's 100. No one can ever say with certainty that this won't happen again. I recently finished a 2-year stint as the juvenile court judge here in Spokane County. I think I enjoyed that rotation more than any rotation I have ever had since I became a judicial officer. Getting to work with kids, with the wonderful probation officers we have, like Mr. Ward or Mr. Stefano or Ms. Spilker, it's really, in my opinion, and I've said this many times to those in juvenile court, I consider it to be the crown jewel in terms of judicial rotations. It is wonderful, fulfilling work. The objective is so different. It's to help kids find their way, to help kids be a success when they become adults, and not come back as adults who end up in the criminal justice system. And in the adult system, those of us who work daily in this area know it's an entirely different thing. It's not all about rehabilitation. It's about providing humane custody, but also providing protection to the public from those members of society who commit offenses against others. Sometimes horrific, unfathomable offenses. So would the juvenile system employ a different approach? Well, of course, would the juvenile system do its best to rehabilitate Mr. Sharpe? Of course. Would it do its best to ensure that the public is safe upon his release? I know the juvenile system well. Of course the juvenile system would do that. There are superb, wonderful, well thought through programs. Can the court risk that with Caleb Sharpe ultimately in the juvenile court, a factor that the court has strongly considered. I have considered this matter in great detail. I am mindful of the tremendous work that has been done by all of the attorneys involved. I have reviewed in detail every bit of evidence that was provided to the court, some which was striking and, to be frank, was horrific for me to see. And I have seen things in 17 years that many of you cannot imagine. And much of what I saw shocked even me. I've been told by not only renowned experts who testified, but also lay witnesses and members of the Freeman community and members of the Freeman High School community how much this affected them. And I want to say again how tremendously sorry I am for your loss. I recognize this has changed all of you forever. I wish there was a way for me to lessen your pain. I do know from personal experience that your pain will lessen. It will become easier, but it will always be there. To be clear, it is not my job, it is not the court's job, it is not my responsibility to do what the Freeman community wants me to do. That's not my role. It is not my job, it is not my directive to do what Mr. Sharpe wants me to do. My sworn obligation as a Superior Court judge to the citizens of Spokane County and the state of Washington is to follow the law and not be influenced by personal preference, prejudice, sympathy, or passion. In this instance, I intend to follow the law, especially so as it relates to the Kent factors that I have reiterated, which have been for many years the law in our state of Washington. Mindful of all of this, I am satisfied that when employing a preponderance of the evidence, that the court should order that this matter shall be declined to the jurisdiction of the adult court for all further proceedings. Mr. Haskell, Ms. Fitzgerald, as the moving party, the court would impose upon you responsibility to draft orders reflecting the court's ruling today. I expect you're going to need some time to do that. My judicial assistant emailed me a presentment date, which I can give to you now. But first, let me start with the state. Questions I can answer for you, sir?
I have no questions, Judge. I will take the date that the court is setting for the presentment hearing. I would like a copy of the transcript of this proceeding.
I anticipated that. And counsel, just because of my schedule following a couple different dockets that I'm required to rotate through right now, Ms. Dorman gave me a potential date of August 16th at 8:30 for preparation of orders to encompass the decision today at 8:30 in the morning without oral argument.
8:16 at 8:30, yes, Judge. And
yes,
also, at that time, the state would also propose that we arraign Mr. Sharpe in adult court on the amended, that would be the second amended information.
Yes, sir. Ms. Fitzgerald, will that work from your perspective schedule-wise?
Yes, Your Honor, if it works, I'll prepare a scheduling order as well for transport.
Okay. My judicial assistant's generally one step ahead of us, and she mentioned the arraignment, so the plan is August 16th, is that right?
Yes, Judge.
All right. Mr. Maxey, questions I can answer for you, sir?
I do not have any questions at this time.
All right. Thank you, sir. All right, folks, let me make one final comment, and that is to say again to all of you, I apologize again that the court was not able to accommodate everyone in the courtroom all at one time. Perhaps someday we'll get bigger courtrooms and we can be of greater assistance in that regard. But I want to make one final comment again, which is to say, despite this ruling, I know there is a lot of pain by everyone involved. And I respect that. And of course, I wish you all the best. And thank you very much.